Hello everyone. So in this video, again in this series of video, we'll discuss some of the important bills. In the last video, I have discussed the Mines and Mineral Development Bill. So in this series of lectures, we'll discuss some of the important bills of this year, which are very relevant for your examination. In this video, we'll discuss the second bill, which is Mediation Bill. So let us start with the Mediation Bill. Now, these are some of the features that is being offered by this particular bill in the monsoon session. But let us first talk about what is actually mediation, right? So, mediation is basically a voluntary process in which parties try to settle disputes with an assistance of an independent third person, which is called mediator. So, basically, mediator resolve the dispute of the parties, and the mediator is an independent third person. Now, the mediator, which is this independent party, does not impose a solution on the parties, but they create a conducive environment in which they can resolve their dispute. Now, the mediation process depends on the choice of parties, and there are no strict or binding rules of procedure. Unlike litigation or arbitration, which involve adjudication of dispute, mediation involves settlement with the consent of the parties. And it is legitimized by Section 89 of the Civil Procedure Code 1908. So, Section 89 talks about alternate dispute resolution, which involves arbitration, negotiation, mediation, conciliation, and then lok adalat, right? And mediation is a form of alternate dispute resolution, right? So the genesis found in Section 89 of Civil Procedure Code. Now let us talk about this bill, which is Mediation Bill 2023. Now, this bill requires persons to settle the dispute through mediation before approaching any court or tribunal. So, again, this bill promotes mediation before you approach any court or tribunal for, again, civil matters. So, remember this, that these kind of things are allowed only for civil matters. Now, in this, the parties may withdraw from mediation after two mediation session. So, this is being governed under this bill that you can withdraw from the mediation after two mediation sessions. Now, the mediation must be completed within 180 days. So, again, one of the special feature of alternate dispute resolution that it provides timely dispute settlement, and that is why in civil cases major companies approach alternate dispute resolution, especially arbitration, right? So the time period under this bill is 180 days, but again which can be extended by another 180 days by the parties, right? Parties can again extend this process for another 180 days by giving sound reasons for that. Now, the bill also creates Mediation Council of India. It provides for settling up the Mediation Council of India, and the functions include registering mediators, which is the third party, independent party, and recognizing mediation service providers and mediation institutes that will offer the mediation process. Now, the bill also covers two forms of mediation. First one is voluntary mediation, and second is mandatory mediation. So, a voluntary mediation is where parties under a written mediation agreement seek mediation. Such an agreement may either be as part of a contract or exist independently. But when we talk about mandatory mediation, it is where, barring certain areas of disputes, there is a legal obligation on parties to mediate before approaching a court or tribunal. So, again, these are just forms of mediation which are under this bill, right? Then the last thing is the concept of community mediation. So the disputes the disputes that likely to affect peace, harmony amongst the residents or families of any area or locality can be mediated and settled by a panel of mediators appointed by the concerned authority. And that is the concept of community mediation. Right? So again, these are some of the features of this mediation bill. Now, what are the areas that are being excluded in this particular bill? So these are some areas which are being excluded by this particular bill. Now, the areas excluded are serious allegations of fraud, criminal offences, environmental matters which are reserved for NGT, National Green Tribunal, and matters relating to competition, telecom, securities and electricity law, and land acquisition. Now, the only issue in this entire process is that by default, the central or state government cannot be mandated to mediate unless the dispute is of a commercial nature. So, you can just think about like Section 89 firstly, because Section 89 of Civil Procedure Code gives power, gives an alternative for resolution of disputes, and these are some of the ADR forms. First one is arbitration, and you know this from Arbitration and Conciliation Act 1996. Then comes mediation, which is again, which was not very binding in nature because of any lack of law. Now, because the bill is being provided, so they will give you some sort of agreement, like the award which is given under Arbitration and Conciliation Act when we talk about arbitration. So same in mediation, it will be known as mediated settled agreement, MSA. Now, negotiation, conciliation, and lok adalat. And in this video we talked about mediation. So again, for your examination point of view, for your legal point of view at least, you need to remember these, some of the features, which is again very important. And one of the forms of mediation which is being discussed in this bill, and the main aim of this bill is to promote institutional mediation. So you need to remember this, that it is a form of institutional mediation which is being promoted under this new bill. So that was the main idea about this bill and how you approach in this topic, right? So in the next video we will discuss the next bill, which is Forest Conservation Rules 2022, and then we will discuss the Forest Conservation Act 2023. So thanks so much.